Welcome back to Sue Your Baby Daddy. My name is Gianni Avalos, your host, otherwise known as the Single Mom Attorney. Today we have very, very special guests with us. Our first guest being Allie out of Philadelphia. She is a family law attorney, also on TikTok, which is how we met, and she also practices criminal defense. Also with us today is attorney Jody, which is an attorney at my law firm, Avalos Family Trial Attorneys, and she practices exclusively family law within our firm, but prior to also practiced criminal defense also with family law. So Allie, thank you for being here today all the way from Philadelphia. Is that correct?
That's correct. Thanks for having us.
Tell us a little bit more about yourself, your practice, and just in general.
Sure. So I own an all-female run law firm.
Awesome.
It's known as Croft-Hamill Law Offices. We practice in Lehigh, Northampton, and Philadelphia counties in Pennsylvania. 2 associates under myself and several legal staff. Primarily focus on family law and criminal defense. I am mainly the family law expert at the firm, and some of the other girls practice criminal defense. So that's what we do at Croft-Hamill Law.
Love that. Jody, at the firm that you were at prior to coming to work for AFTA, right, you practiced some criminal defense as well, right?
Yes, I did.
And did you see a big, intersect between the two practice areas?
Definitely. I actually started my career practicing primarily criminal and then transitioned into family. But there's a lot of overlap, particularly when we see cases involving family violence.
Yeah. And so I definitely want to, highlight that while the two practice areas are different, like she said, they do overlap, but I also want to talk about, how they also differ from state to state, because both family law and criminal defense can differ from state to state. It's not, unless we're talking federal criminal, right? But in general. So, Allie, tell us a little bit about your experiences with that, how it helps you understanding and having knowledge in both practice areas.
Yeah, sure. So when I first started, I was a public defender part-time, and all of my clients would come to me and say, hey, I'm in the middle of a domestic violence incident, and now my kids are being taken away from me, or there's a PFA that's lodged on me, which is otherwise known as a restraining order, maybe in Texas, I'm not sure, protective order. What do I do about this, right? And so then I started learning family law because I basically had no choice, because I wanted to help my client and be a well-rounded attorney and helping them with the situation, but I didn't know what I was doing. So I, of course, used my resources to start learning how restraining orders and PFAs and domestic violence charges, or being the victim of such, affects custody, and it does. It's actually one of our 16 custody best interest factors. It's a huge one for us. So the judges want to know about that when assessing custody.
Yeah.
So.
And you're a mother as well, right?
I am. Yes.
Just had a baby.
I just had a baby.
She
yes.
doesn't look like she just had a baby. She's beautiful.
Thank you.
But do you find that you are able to understand your clients, not just mothers, but parents in general, in a way that maybe other family law attorneys, don't have certain personal experiences with? How do you?
Yeah, particularly when I have, for example, somebody who's charged with simple assault, right? That could be a bar fight, that could be a slap, that could be something very, very minor, right? And then the other parent has filed for a modification of custody for full custody. And it's like, okay, what do I do now? Like, I got in a bar fight. Maybe I had a little bit too much, and now all of a sudden my kids are being taken away from me, right? So I have to be 2 different people at that point, right? I have to fight the charges, for lack of a better term, or deal with the harassment and explain to a judge that, listen, that was, I was out with my friends, I didn't have my kids, I was the non-custodial parent, things got out of hand, this was a one-off, and that doesn't mean I'm a bad parent, right? There's other times where I'm doing the opposite, right? Because it may be domestic violence in the home, and then I'm saying, hey, judge, we have a big problem because kids are witnessing this, right? So it just depends on what the situation is, and no case is the same. But I do feel like I have to understand where the parents and the children are in those situations.
Allie, I wanted to circle back on something you said about the difference in terminology from state to state. I believe you referred to it as a PFA there in Pennsylvania. In Texas, we actually refer to it as a protective order. And so what most people see on a television show like Law and Order, oh, we have a restraining order. That's not what we call that in Texas. And a restraining order is actually something very different, though it can have similar elements to what could be found in a protective order. But a protective order in Texas is the mechanism that is used for a victim of family violence or harassment that can, a legal order that would tell that person who's doing something wrong, who's harassing them, who's abusing them, to stay away from their work, and put a number of prohibitions into place for the victim's safety.
Yeah, yeah. And so just do you find that the mechanisms that a protective order provides in Texas is similar to the PFA?
Yeah, so in the PFA in the state of Pennsylvania, it is only for physical violence or threat of physical violence. So a lot of people want to get a PFA because you can get temporary sole legal and sole physical custody through the PFA. But calling someone, a name or fighting with them on the phone doesn't qualify for a PFA. So in our state, it has to be physical. In New Jersey, which is right over the border from where I practice, where I'm not barred, it does not have to be. So we get a lot of clients who, it's borderline abusive, and honestly, it's probably emotional abusive or mental abusive, but I can't advise them to go get a PFA because it's not physical, which is honestly a lapse in our judicial system, I think.
I think it's interesting. I always wondered, like if I was in Texas, but I was maybe practicing over in Lubbock, right? Like where it's the border of Texas and New Mexico. So you practice in what I understand to be somewhat of a border town, right? The city of Philadelphia. You said New Jersey's right there. Do you find that the cases that you have parents where, one lives in one state, Pennsylvania being Philadelphia, and then the other one, how do you handle that in your cases?
So the biggest issue we have is jurisdiction, right? So where the child has resided for the past 6 months. The issue comes into place if we have no existing order and the parents are sort of doing what we call a handshake order, and they're swapping the kid constantly, or they're, maybe absconding with the kid or harboring the kid or sending the kid with grandparents. Where has the kid lived for the past 6 months, especially if they're not in school, right? So then we have a jurisdictional problem. And so then we're oftentimes in court and the judge is like, well, why should I hear this case? Where's the kid been? And it's like, Judge, everywhere, right? Like,
and then one parent wants it heard in their state, and then the other one wants it heard in their state. Jody, we have those cases as well within the firm. How do you advise the clients on, whether or not we're going to be able to, maintain jurisdiction here, if the other parent is challenging it? How do you go about that with them?
Yeah, so in Texas, we have the same standard, obviously from the UCCJEA,
Right.
where has a child been living primarily for the last 6 months. But the law does also provide provisions, that if a child has been taken away improperly, that wouldn't necessarily impede that 6 months for determining jurisdiction.
Yeah, yeah. It can be very frustrating, I think, and having to explain that to clients, right? Because even probably them just listening in on our podcast episode, they're like, that sounds like a lot of like legal mumbo jumbo. All I care about is that my kid is safe, right? And so like, Allie, one of the things that I really appreciate about what you do as well, like on your platform, is that you really do take the time to like provide educational content and, also empathize with the clients and what they may be going through. So do you find that having, being an attorney on social media, that the clients find you on social media, they come to your firm, you've already somewhat gained their trust. So whenever you're speaking to them about legal jargon, they're understanding that you're still on their side, whether they understand it or not?
Yeah, I think a lot of people come to my firm particularly because of my social media and also because they like a strong female, and they know my firm is all female.
Yeah.
So they really want to feel secure with a female, whether that's a male or a female.
Yeah.
So they do have my trust.
Yeah.
But also,
Future is female.
but also I try to talk non-legal to them as much as I can, because I know when I go into a doctor's office, for example, and the
Yeah.
doctor starts saying, oh, well, you may have this, and that. What?
Yeah.
Come again? Right? Like, give it to me in what I call layman's terms. Like,
I'm like, explain it to me like I'm 5 years old.
exactly.
It's like,
So I try to do that. And I also have made like sort of like cheat sheets for my clients where, okay, step one is we file a divorce complaint. What does a complaint mean? And then I like put it in like, you
Yeah.
know, terms that everybody can understand. So I think that's helped too, because oftentimes some people, if they read it rather than hear it, they understand it better. So
Yeah.
I try to do that as well.
I agree. I think that that's one of the things that we have to really remember as practitioners is that, like, how do we get client control? You know, the clients trust us, right? But how do they know to trust us when they don't understand what it is that, you know, we're asking or we're telling them, we're educating them on? They see us making an effort to at least try and educate them on what it is that we need them to understand. And how do we do that? We understand and come to accept that not everybody registers information the same way. Some people, they do want it in an email so that way, you know, if they don't understand something, they can go back and read it, right? Some people, they want it over the phone because they feel like that's just how they're going to register their auditory like learners, right? And then there's other people that they're like, I want you to like literally draw it out for me. I want like diagrams. I want, you know, the cheat sheets. I want different colors. And so it's, you know, we live in a new world, and I love that social media presents us with the opportunity to, you know, for the people that want to watch it, they can watch it as well, right?
Yeah, they can watch it, and I often do multiple of things that you just described, right? So I may have a conversation with the client on the
Yeah.
phone, then follow up in an email, and then they're like, but you said this on the phone, right? And then I'm drawing a diagram and sending them it, you know, scanning it to them so they understand.
Yeah.
And I get it, because like I said, if I go to a doctor's office, my head's spinning when I leave there unless they break it down for me. So, and also, like, this is their kids, these are their life, this is their wife, this is
Yeah.
their husband, like, this is everything to them. So I want to make sure that they understand that I care,
Yeah.
and whatever it takes for you to understand what I'm saying, we're going to do that for you.
Yeah. Did you tell us a little bit of about your background? Like, did you come out of law school and then start your own practice? Did you work for another firm?
Yeah, so I graduated law school and then worked for a workers' compensation firm for 4 months. And the owner told me that women don't belong in this profession. And
At a workers' compensation. It's like,
yeah,
that's crazy.
I handed my 2-week notice immediately to him, and then opened shop with a partner who I'm no longer with in 2020 in the start of COVID, which probably was not the best idea looking back. But we worked with it, and I was part-time public defender at the time, gaining private clients. And then I separated in 2022 on my own without a partner, and been here since.
I love that. Yeah. It's interesting. We always hear those stories where it's like women get discriminated against, and comments as explicit as that, right? Like, women don't belong here, right? But we have to understand, like, it's happening more than what we hear about. Like, whenever I was applying as a family law associate coming out of law school, I knew I wanted to get back into family law, right? So I was applying, and then I had a previous employer call me, and they said, hey, I know that you had applied to this one firm. They called asking for a like a reference, you know, but they were putting me like on notice of the fact that the potential employer was already anti-single moms. I guess at that time my social media was already kind of taken off a little bit. They looked me up, and they were like, oh, well, you know, the reference that you have given us about her sounds great, but that was before she became a single mom, and we don't think that she would be as hard of a worker. And so I felt like I needed to know that that's what the potential employer had said about me, right? Because that's what sparked me to just open up my own firm. I said, if this is how I'm going to be viewed, even in a place that I'm coming to apply to, like, I don't really like what are, and that lawyer was bold enough to say it out loud. Other lawyers may not, other potential employers may not be bold enough to really say it. So I knew in that moment that I needed to start my own firm. Do you have you found a great benefit in just being able to run your own practice at this point?
Yeah, I love it. I love it because, you know, I can take cases, I can help people, I can sort of call the shots, right? So oftentimes, I'm sure you experience this too, we have people coming that need our services desperately, but, you know, you quote a retainer and they can't afford it, right? So I have the ability now to take the case pro bono, discount it, assign it to an associate, you know, drive maybe to a county that I'm not used to help somebody. So that's what I like about it. I am very much live by the pay it forward. I have it tattooed on my arm. My grandfather instilled that in me. So I try to pay it forward when I can to help people. It's mostly single moms and moms that have been suffered domestic violence or family abuse. So that's what we get a lot
And
of.
that's actually, I mean, you touched on pro bono. So that's actually how we met, right? So another way that social media is very powerful, right? There was this young mother that is was and still is going viral for her, the situation that she has found herself in. And a lot of people were tagging like at single mom attorney, at single mom attorney. They wanted me to do something about it. I, messaged her and I said, hey, like, what state are you in? She said, Pennsylvania. And so she said that she was in Philly. At the time, I don't know if we followed each other. I think we followed each other on TikTok. Yeah.
Yeah, we just followed each other.
Right, right. But I guess I didn't think, oh, well, Allie practices in Philadelphia, right? So then I had posted it on my social media like, hey, while I cannot service, right, this client, I can help her in a way to just put the message out there. Like if there's any attorneys licensed in Pennsylvania that practice family law, if you're willing to come forward, like I'll pay for the consultation, like my firm will pay for the consultation for this mother. And then, Allie, just being the good person that she is, she was like, no, I don't need the money. Like, don't worry about it. I'll talk to her and whatnot. And so I find that those things, those stories need to be told because, the state bars that we practice in sometimes don't recognize the significant value in being an attorney marketing on social media. We're held back a lot. Do you find that that's similar in Pennsylvania?
Yeah, so like I often get New Jersey, right? Like you do for New Mexico. We get, I get people messaging me, hey, could you help me out? Could I set up a consult? But I'm in New Jersey. Like I could spit over the Jersey border. And I'm like, no, unfortunately I can't. But I know, a vast majority of lawyers that I'm sure I can refer you to. But that's the one thing that really bothers me about the bar. Like I understand that each state is so specific and you have to like master the law. And I understand why it's in place. But I just wish I could help people surrounding me because it's not that far, but I can't because I'm not barred. So that's where, things like this that we've met on social media, the networking helps, right? Because I wouldn't have known you if it wasn't for social media, but now I know you. And, if somebody would say, hey, I need a divorce lawyer or a custody lawyer in Texas, I would immediately contact your office.
Yeah.
And I think that goes for, every state. It would be nice to have some kind of female, network where we could say, hey, we're in this state, you're in this state, and just like kick it that way because otherwise, your hands are kind of tied.
Yeah, exactly. Jody came to us from a previous firm, right? And how long were you with that firm?
I was there for almost 7 years.
Almost 7 years. So I feel super honored that I was the one that she made the jump to when she transitioned out.
Well, I saw what you were trying to build, and I know that you said that, women are still discriminated against in the legal field because historically it's been the domain of men.
Yeah.
But that, like you said, the future is female, and that's very much changing. Now we're seeing law school classes are made up of a majority of women, and I think as these young women graduate and they become attorneys, hopefully they'll continue doing what you're doing, where we're creating environments that are more friendly to women. They're more friendly to single women particularly.
Yeah, exactly. What is something that you look for, or, I know that you liked our mission and everything, but what was another thing that you were looking for as an associate, looking to apply to other family firms?
I was really looking for someone who was really creating an environment like you that wasn't so focused on kind of an old school mentality. But I also really liked how you really want to help people. And so like Allie said, maybe somebody doesn't have the money for the retainer, but you're always looking for ways to help people and make things workable so that you can serve the clients that we're trying to reach.
Yeah. I had, and I know that they meant it in a way that was complimenting, right? They complimented me saying that I'm like a disruptor to the industry, right? And that's what I said. Like, I want to see more disruptors. I want to see more of Allies. I want to see more associates that want to work for disruptors. We have other lawyers on social media, and the reason that they're challenged so often is because we're successful in what we do. And that can feel very uncomfortable to somebody who doesn't know how to use social media, that's a lawyer and whatnot, right? And that's running their own firm, realizing like, oh, I'm not getting as much business possibly because they don't understand how to work social media. And I always tell people like social media may not be your way to market. Just because you see that it's working for somebody else doesn't mean that has to be the way that you market your firm, right? There's a lot of other marketing avenues. But more importantly, it's about like being yourself, right? It's like she said, she's like, I recognize that not only, the mission was to ultimately help people. So do you find that like maybe there's some creators, there's some people that ask you for advice and then they try to like mimic you and it feels inauthentic?
Yeah, I also feel like they try to mimic me, creators, but I also feel like when I go into the courthouse, I don't know how it is for you guys, but we're very small town, like very small town, okay? So we have like 9 judges per county. So I don't know if that's smaller or bigger than where you guys are, but it's very small. So like everyone looks like I get very much like, you know, my staff will be filming me outside the courthouse,
Yeah.
or like I'm talking to a client and they want to be on my TikTok, so they'll film me, right?
Yeah.
And like these older particular males will like look at me like, what is she doing? Like she's what, you know, aren't
There's
you
a
working?
stigma.
Like what are you
It's a
doing?
stigma.
Like and like I've had experiences I'm 31 years old, so I've had experiences where I, you know, show up to courthouse and I'm dressed, you know, in a suit like we all are right now, and are you the stenographer? No, I'm the lawyer. Thank you very much. Like,
Yeah,
why
I've gotten that.
yeah.
Are you a paralegal?
Are you like, why are you asking me that? Because I'm in a suit and carrying a briefcase? Like, don't assume that I'm
Yeah.
not qualified enough to sit here and argue this case. And that's the stuff that bothers me. And I don't want to stereotype, but it's particularly males
Yeah.
that say this stuff to us. Like, most females in our industry, for me, at least in our small town, we kind of root each other on, like, hey, I
Yeah.
can't do this case. Let me throw it to you, or conflict or whatever. But the males, I mean, I never refer to males. That sounds horrible, but it's the truth. I very rarely refer to males because they
Yeah.
don't appreciate it. They're not throwing it back, and
Yeah.
it's like, who are you? You're some TikTok lawyer, and you think you can own the Lehigh Valley because you've been practicing for 5 years, and it's like, yeah, but I'm doing it right.
But you're
Like, look
you're
at my-
doing something. Yeah, exactly.
Look at my business, right? Like, and I'm like more the merrier. Like I share the wealth. Like,
There's
hey,
enough
you
to
want to
go
come on
around.
my TikTok? Come on, buddy. Like they don't, but they're like, TikTok, what's that? I don't know. Yeah,
Yeah,
you know.
yeah.
And it's just like, so it's very much like we are the start of that. I think. Like
I think we are, yeah. And I recognize that I was very, very blessed, also from a small town. Whenever I was first starting my law firm, I didn't want anybody to know about single mom attorney in my town. Like I hid it. I just kind of got on the appointment wheels. I didn't say anything about any of it. In Granbury, I was law office of Gianni C. Avalos. In Dallas, Houston, we were still getting, I mean, I was a true solo at the time. I was still getting cases over there. And for those cases, I was single mom attorney, you know? And so I did like a silent like DBA, you know, for those cases. And then Granbury, I was like law office of Gianni C. Avalos, right? But I guess somebody found it. They brought it to my attention one day in like a very lighthearted way. And then the judge, you know, was like, hey, I didn't know that this is what you're doing and everything. I was like, yeah. So they just had a lot of questions, but we should welcome the questions, right? If they mean them in the right way. But I agree. It's interesting to see that like not only in Texas is the family law profession still very traditional, but it sounds like it's still in that very similar in other states.
yeah, it's very traditional, by the book. We're gonna follow this. You know, we don't use computers, iPads. You're coming in with a trial binder, you know, the size of this table, right?
Yeah.
And you're lugging your papers with evidence stickers, and I'm like, what are we doing? Like,
Yeah.
I'm very much, my firm is non-traditional in the sense that like I let my staff work from home. Most of them come in and out when they want. We all use computers and iPads. We have electronic file. We of course have a hard file because I don't have a choice.
Yeah.
But we, you know, very much use like an app to communicate between each other.
The efficiency is there.
Yeah.
Yeah.
At some older school firms, like I walk into like for a 4-party meeting on a divorce case, I'll walk in, there's like no computer. It's like an old dial phone. I'm like, whoa.
I got into the legal industry maybe like not I don't know, a little 10 years ago or something, right? But the first lawyer that I ever worked for still had an old school like typewriter for the LLC certificates.
Oh my.
And I was like, how do I work this? Like, I was supposed to be the one that was typing it all up, you know? He was like, well, you know, you just put the paper in there and then you start typing away and then you move it and then you move it back. And I was like, there's got to be an easier way to do this. Like, why are we still doing this? And I still make light of it because then his calendar, he never knew, I mean, he didn't have like a Google Calendar on his phone or anything. So if he was in court and they were conferencing about court dates, you know, he would call the firm and then I'd answer. He'd be like, Gianni, like what day does my calendar on my desk say, you know, that I'm available? And I was like, there's got to be an easier way that you can be doing this. Like, what would you do if I wasn't there, right? But yeah, I'm excited to see more disruptors in the industry. Jody, do you find it not only different in the culture of our firm, but the way that do you see a difference in the client control at our firm versus other firms where maybe they don't see the side of us on social media prior to retaining? Do you feel like we may already have gained their trust in some kind of way by the time they get to our firm, or do you like compare it to other firms that you've been at?
Yeah, so I think that because of the online presence, like Ali was talking about earlier, that's a way to build trust and to educate clients before they ever even walk into the door and become a client and have that initial consultation. So you're kind of starting with that baseline. And I also think one of the things that sets us apart is just the communication. You know, in every firm I've been in, when we'd get clients coming who already have representation, a lot of the feedback we would get would be, my attorney's not updating me. I don't know what's going on. And, you know, using technology now in the case management systems that we have, it's really easy to keep clients updated. It's really easy to share, you know, have a running Dropbox folder where they can go and they can see the pleadings that are actively being filed in their case. So those tools to keep the clients updated and to keep them educated throughout the course of their case is very helpful.
Yeah.
Do you guys have, I'm sure you do because you do family law, but the biggest thing for me is like we keep our clients updated like you, case management software, like the 4:30 exchanges on a Friday, right? For family law, like our phones ring off the hook because there's always some kind of emergency, something had a custodial exchange, holidays in particular, right? So PFAs before holidays, right? So I think what we do is like, so my staff will accommodate, like we know what's coming because it's just the way the orders are written. So we are very much like, I pride ourselves like an all hands on deck customer service. So like if there's an emergency going on, like they can call our law office and speak to a lawyer like as soon as possible. If a paralegal can't assist in some way, or if none of us are available, it's a 911 text, right? But we see that so much, and it's particularly around holidays or PA loves 4:30 Friday exchanges, so right. So we see that all the time. Is that something you guys experience too with the?
Yeah, I mean, I really admire lawyers like you, right? That have adopted that approach like our firm as well. We're never going to be too good to pick up the phone and just answer a question that probably will just give them, it'll take us 2 minutes to answer, but it'll give them the weekend with a peace of mind, And so we do see those moments where if it's like a holiday that's going to be on Monday and they don't know how to read their custody order because,
it's written
it's
in legal
complicated,
jumbo,
right? I mean, even sometimes there's some that are customized and I'm reading them and I was like, I need to read it 3 times to understand this. Like, what are they meaning here, right? So I recognize that it's important to understand that the clients may not understand their order and they have questions. Do you see that a lot too?
Definitely. I think especially in Texas where we have the standard possession order, and we were talking about this earlier, right, about how you really need to know your audience and be able to break down the information and make sure you're tailoring that to the specific client, because one client may be able to understand something more easily than someone else. But we need to remember that as practitioners, like you said, because we do this day in and day out. So when I say standard possession order, to me, I'm running off all the things that I know it consists of in my head.
Right.
Whereas a client who is brand new to family law and brand new to the standard possession order, it's incredibly nuanced.
Right.
And there's so many, exceptions. It kind of reminds me of studying for the logic games on the LSAT because you have all these rules. If then this.
Then that,
if then, for example, when we have a holiday, right? Memorial weekend is coming up.
Right.
And so under the standard possession order, when there's a holiday following the non-custodial parents' weekend, it actually extends their visitation time. And so, and I always encourage clients when I send them a copy of an order, I say, hey, read this at least 2 times. Go page by page and make a list of questions and things that you don't understand so we can go over this together before this ever hopefully becomes a court order so that when you're going into this, you know exactly what the expectations are so we have fewer instances of confusion and hopefully fewer Friday phone calls when something's gone wrong at an exchange.
And that seems to be where a lot of moms are disserviced here is like if they apply for child support, they're going through the OAG's office. In Texas, you're going to get a possession order that is accompanied with that child support order. It is one order. It's not, the issues are not bifurcated, right? Under most circumstances. And a lot of the times the OAG will just say, oh, just agree to this. And then they say, well, I didn't know what I was agreeing to because you have only 20 minutes to review it or something like that. And then the OAG is telling them, well, it's only if you don't agree, this is the schedule that you'll follow, right? And it's a disservice. I wish that we were like other states where if you apply for child support, then okay, like that's what you're going to get. But possession and access can be so complicated that I'm like, that needs to be explained to them beyond just an OAG settlement negotiations conference.
Absolutely, and I think that brings up a really good point. I was representing a father several years ago, and the OAG had initiated a case, and we showed up to court, and mom's there, and the OAG is there, and mom didn't understand that the OAG represents the state of Texas. The OAG really doesn't represent mom.
Yeah.
And so when we removed that case from the Title 4D OAG court and
Right.
we removed that to district court, mom kind of, and I almost
Yeah.
felt bad, right?
Yeah.
Because she was there,
Yeah.
without a true attorney who was there to solely represent her
Right.
interests, right?
Right.
With the OAG's there, of course they want to be helpful. Of course they're going to help facilitate, but they're not really there
don't
representing her, right?
And it can be-
taking an individualized approach.
Correct. And it can be confusing to them because it may seem like they're on the same side, both saying that, Dad needs to be paying child support, but you're right, they're not her advocate. What do they have something like Office of Attorney General in Pennsylvania that people can go and apply for child support? What does that process look like for them over there?
I was just about to say, you guys
Yeah.
are talking about possessions and OAGs, and I'm an attorney, and I have no idea what you're saying.
Yeah.
Well, that's such an
Because-
important
yeah.
point of how the law varies so much state to state.
Yeah, I'm like, what are you guys saying? I have no idea because
Yeah.
we don't whatever acronyms and we don't use those words. Like we have our own acronyms, of course, but I kind of can get
Yeah.
what you're saying, but I actually have no idea what you mean.
You had made a video recently talking about, I think that in Pennsylvania, correct me if I'm wrong, y'all use the terms legal custody and physical custody, right?
Correct.
And we get those questions all the time, like, oh, well, I think I have legal custody over him, or I think I have physical custody of the child. And in our terms, in our minds, we're thinking about it like we don't use we don't use that terminology, but what we do use is, conservatorship, the way that I understood it in your video, we would call legal custody conservatorship.
Oh, okay.
We would call possession and access what you call physical custody, but then I still feel like I need to explain it in an even more specific way to the clients, because if a client just hears the word conservatorship or possession and access, like to us, it just registers for what it is. But I'm like, no, like, so conservatorship, when you think about conservatorship, you need to think about like what rights and duties do you have as a parent, who's making the medical decisions, who's making the educational decisions, and then in terms of possession and access, that's the custody schedule, and then they're like, oh, okay, I get it now.
Who's
Like,
the child with and when?
who's the child with and when, who gets to make what decisions, right? But do you think that states will ever get to the point? I mean, they've made the efforts and they've succeeded in the efforts of having like the UCCJEA, UIFSA, so there's some uniformity in family law to an extent. But what about just something as simple as like, can we just all say it the same way? Like, do you think that we would ever get to that point?
I hope so, because the way that you're talking about conservatorship, and like if I went home and said to my staff, hey, we need to get this client conservatorship, they look at me like we have 8 heads,
Yeah.
right? Like, so, and also I think it's very like specifically conservatorship, or what we call legal custody, which is decision making, if I'm understanding
Yeah.
correctly, regarding the child. We never in our state, it is extremely rare to get what we call sole, which means one parent deciding that. So like we call it shared legal custody. So both
Joint managing conservatorship.
both parents make the decision. So unless they're like in prison, unavailable, have made horrific decisions regarding the child's medical or dental or something like that, you will not get sole.
Let me ask you about that, because in the law in Texas, just like Gianni said, our standard is joint managing conservatorship, but sole managing conservatorship is going to be awarded typically when domestic violence has been, committed against either the, the parent, the primary parent, or the child potentially. So how would that work there in Pennsylvania? I know you said it would have to be something truly egregious. In Texas, it's just, has there been an affirmative finding of family violence
yeah.
within 2 years preceding the filing of the case? And of course, there's other circumstances that can lead to sole managing as well.
Right.
but it would be more of an exception.
So it sounds like over there that you really do have to co-parent with your abuser then.
Oh, yeah.
Yeah.
I mean, so we even have, which makes me kind of sick as a female, but we have like a PFA, which you guys have protective orders, same idea. They're in the PFAs, they will write PFA except for custodial purposes only.
Yeah.
So,
Which is how they
And
get
what
you.
does that mean? And I'm so glad you brought that up because I've experienced the same thing, right? Where we basically say, you know, the whole nature of a protective order is literally to say, hey, someone stay away from me. Don't
Yeah.
ever,
There's
don't
yep.
ever
Yep.
contact me.
Yeah.
But then it gets so much more complicated when a child is involved. And exactly
Right.
that, I've written that language in, except for, you know, communicating about significant information regarding the child's safety, welfare, education, and health. But it's like, what does that really mean?
Yeah, yeah. It's like I think that whenever Jody started, this is how I knew. I was like, she's really thinking like she's not a mother herself, but she's able to put herself in the shoes of a mother. We were talking about app close, or it was like, you know, the co-parenting apps, right? And a lot of the times the clients will come and tell us that they're like, oh yeah, no, I can block my baby daddy because our order says that, you know, we have to communicate through app close, our family wizard, whatever. But, you know, whenever I was talking to Jody about that, she had already pointed out what I was going to say. She said, except for that provision that says, you know, you're going to communicate through this app unless it's an emergency.
Yep.
So I'm like, well, now what you've effectively done is you've eliminated the opportunity for that mother to block him. And now she always has to have that line of communication open in addition to app close. Like it would have been fine. Like if we're going to use app close, if we're going to use the apps, let's just say that that's what we're going to use, you know? But instead they invite the whole like, well, unless it's an emergency, but it's like app close still has the, you know, the mechanisms to like call your co-parent. It's still a texting app. Like there's nothing else, you know what I mean? That
Do you think that's rooted in just a lack of understanding and
I think so.
technology with maybe an older judiciary?
I think
or,
so.
And
Yes.
not necessarily just the judges themselves, but also practitioners. Because we've talked about how, you know, the old guard,
Yeah.
right? And kind of wanting to implement technology to make our practice more efficient. But I think
Yeah.
that has something to do with it. And I definitely think that's something that
They're
we need to
not-
look into. And
yeah, they're not putting themselves in like the day-to-day of the litigants. And that's what really frustrates me. Another thing that you had brought up when you started working here was that the rights to make psychological decisions and psychiatric decisions are two, I mean, we combine them. The family code just says, you know, okay, this parent is going to have like the exclusive or the independent or the joint right to make those decisions. But when you think about what psychological decisions are in comparison to psychiatric decisions, you know, Jody was like, it's very dangerous for both parents to have the right to make decisions regarding the psychiatric, because what does that mean, right? So you were mentioning how maybe if one parent agrees to, or, you know, agrees with the psych saying, yeah, my child has ADHD, you know, they need to be on meds. But then if the other parent says, no, I don't agree with this. So now we're like just not going to give the kid medicine, or now we're just going to, God forbid, give, you know, two different types. Like, that's what I'm saying. I think that the judiciary, the legislature, like they need to look at these situations like, we're not just making decisions that we should be copying and pasting from the family code and not changing, not reviewing, not evaluating. Back then, you know, therapy was a lot less common than what it is today. And so it takes a younger generation to recognize like, hey, we are seeking more mental health services, and that looks like X, Y, and Z, right?
So in our state, like, for example, you gave that great example about the meds and the kid has ADHD. They got an eval. Mom says, yep, we're going to follow doctor's recs for meds. And dad says, oh, heck no, my kid's not going on these meds.
Yeah.
So our judges suggest, or our mediators suggest, okay, if you have shared legal custody, conservatorship for you guys, and you want to put your kids on med and dad doesn't agree, you're going to file a petition for special relief or an emergency motion. You're going to go in front of a judge, make your case, then the judge will decide what's going to happen to the kid. And by the way, you're going to keep shared legal.
so a judge is deciding the care as opposed to a doctor.
And then
Correct.
also, what does that mean? That just means more attorney's fees for these litigants.
That's what I was just going to say. It solves
Yeah.
nothing. So now, every time there's a problem, like, for example, I get it all the time for private public school. All the time, right? And it's like, oh, I want to put my kid back in public school because I can't afford private anymore. Or we're going to we have relocation cases all the time. We're going to move to New Jersey or whatever. I'm sure you guys experience that.
Yeah.
And it's like now we're fighting over every single thing. Did the kids get braces? And it goes on and on and on. And I'm like, you know how this could be solved?
If
Give
we were
one parent the decision making.
Yeah.
One. And I know I hate saying that because if both parents are fit, willing, able, and they're just don't agree on views, then maybe it's not the best decision. But 99% of the time, that's not the case.
And they have the tiebreaker.
Yeah,
so do you want to go
that's
on about
exactly
that?
what I was about to bring up and talk about. So in Texas, we anticipate, right, that the whole idea of joint managing conservatorship is that as parents, you should be able to be involved in the decision making for your child, unless you've done something to, necessitate taking that privilege away.
Right.
And so the language we typically use will say that, hey, parents will make non-emergent invasive medical decisions together, but in the event they're unable to agree and reach a consensus, then they agree to defer and follow the recommendation of the treating physician or the specialist that they've been referred to.
But even then, that is not presumed in the family code. It's just something that strategic lawyers, right, that understand that these parents are going to disagree, request in the relief. We request it in the mediations, right? Because we are trying to, in the episode that I did with Caitlin Jorgensen, she said, courts are not proactive, they're reactive.
Yes.
So they're not proactive about anticipating the potential issues. They're just like, oh, if you have an issue, come back for a modification, and then it just, like I always tell clients, like, I hope you never have to use me again. I hope that this order is so good that, if you're going to modify anything, it would just be child support. But I hope that the conservatorship, the provisions that we like to include that are special, like, for example, if he's always running late, to pick up the kids, it's like there is nothing in the family code that says, well, there's a 30-minute grace period. Like, no, it's just based on precedent and that judge's preference of, if mom leaves the place of exchange because he's running late, what does that mean? Does that mean that she's withholding? Does that mean that he can pick up on a Saturday instead? What does that mean, And then sometimes you don't come to find what it means or what they're supposed to do until you go for an enforcement because it's brought upon mom, right? So how do we solve that? We just get more specific in the orders. Like, hey, here's the grace period for both conservators. And if the 30 minutes is, lapsed, then they forfeit their right to that possession and access, or they're going to have to, come to a different place of exchange that's closer to mom, do something to where now you're being proactive with the order that you're writing for the client, I wish that it was just, like, we didn't have to argue and fight so much for those things, because going back to what Jody was saying about the tiebreakers, right, that took somebody, whoever had thought about that, right, because it's not in the family code yet, but somebody thought about it to where it's common practice at this point, right? There was debate about it, though, at one point where they were saying, well, the treating pediatrician or the if they don't agree on an educational decision, they would defer to the recommendation of the school counselor, principal, whatever. Those third-party individuals, those professionals, are not litigants in the matter. So now there was like this whole debate in the family law community about, well, does that mean that we're no longer allowed to put that in the order? But then the counter argument and the reason that we still are able to include that is because they said, no, we're not saying that the pediatrician is going to make the decision. We're not saying that the school counselor is. We're saying that the parties are going to make the decision based off of the recommendation.
It's so funny you brought that up because I was literally just thinking about the evolution of these provisions just in my time as an attorney in the last 7 years. Because when I actually first started, the term or how we were writing that in was basically that the primary care physician would serve as tiebreaker. And it brought up that same issue because this primary care physician isn't a party to this case. The court can't order this person to serve in this capacity. And then so that's when we started revising that to say, no, we're putting the impetus on the clients and the parties to, no, you're ordered to follow their recommendation.
Correct. So language matters, words matter in these orders. Do you find that, absent those common practices, right? Like if you're trying to get creative with your order, do you find that you get a lot of pushback from opposing counsels, or is Pennsylvania starting to become like more progressive with those provisions and more inviting to them?
Yeah, so we very rarely make our own orders. So we will make our orders if the clients agree on legal and physical. custody. So if they come to me, they say, hey, you know, we agree it's going to be what we call 50-50 custody and shared legal. Can you draft up an order? And I would put all the standard provisions in and put all these things that you want and then walk it into what we call motions court and have the judge sign it, and it would be no problem. If we file a complaint and the parties don't agree, they force us to mediation. It is required under PA law. At mediation, there's a mediator, they're a lawyer that's hired by the county to try to come up with, primarily it's the schedule. Then they make the order.
The mediator does.
The mediator does.
Oh, wow.
And then we leave with that order. And then if it doesn't settle at mediation, then we're slated for trial. And then, of course, after a custody trial, the judge makes the order. But I just had a case recently where we were at trial, and before trial started, judge was like, hey, can we hold a quick settlement conference? I think we can settle this. So I'm like, yeah, sure, judge. We settled the case. My client wanted to relocate to New York. He was like, let her relocate. Let's give dad substantial time in the summer. We worked it up, blah, blah, blah.
Yeah.
He's like, I'll get you an order in a week. He gets me an order, and the order was correct. There was no issues with it, but there was...
Your opposing counsel did, right?
No, judge.
A judge. Oh.
I could never imagine a judge drafting the whole order for
Judge
us.
drafts the order, gives me the order. There was nothing wrong with the order. He got like the physical custody and the legal custody correct, and then we have like standard provisions like non-disparagement, use VAR Family Wizard,
Yeah.
Emergency, call the other parent, right? But there's like so many looseness. Like exchanges happen at 4:00. Okay, judge, where?
Where?
So much gray area.
Wow, I would not want to practice in Pennsylvania. Like, from what you're telling me.
And so it's just like, now my client relocates to New York and calls me and says, well, where do I meet him at 4:00? And they have a PFA. And I'm like, well, I suggested that you guys met at Wawa, for example. And she's like, yeah, I thought that's what we were going to do. And I was like, everyone agreed upon it, but it didn't get in the order. So, like, that's
you're operating
the
off of
problem.
a...
Yeah.
Yeah.
So it's just like, I almost wish they would leave it back to us to draft the order and then he or she would approve it, the judge, but that's not how you do it. So unless we agree by stipulation and they never step foot in the courthouse, we do not draft the orders.
Wow. No, we do. In fact, the mediation will probably say, okay, well, the parties agree that either respondent's counsel or petitioner's counsel is going to draft, and if it's silent to it, then it's just customary that petitioner's counsel would draft, right? But I can't imagine having the judge draft it, because then if there's a drafting dispute, you're basically telling the judge, like, yeah, you're wrong, like, you should change this.
And I've done that.
Yeah,
I've
you
emailed
have
the
to.
judge, and I'm like, Judge, I'm sorry, I'm not trying to nitpick here, but these parties are arguing over something, like, where do they meet the child? And he's like, okay, I'll edit the order or whatever it is. I filed modifications because orders were wrong.
That was my next question. So what happens when there's a deficit like that in the order and there's some type of enforcement? Because if I was representing a client who had an enforcement brought against her because she didn't meet the father, I would say, your enforcement is going to fail because it doesn't specifically say the time and place for the exchange. And so if the order is inherently vague and ambiguous, how can you enforce it?
Correct.
So we call them contempts, not enforcements. Fun fact. But we very, 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 very rarely do you make it in front of a judge for that.
Oh, wow.
You're talking like I've probably done it less than 10 times in 5 years.
Wow.
We
So
do.
then how do you reach that rendition for the contempt?
So this is like one of the things I strongly dislike about the way we practice family law in Pennsylvania. So we would file a petition for contempt. It would go in front of the mediator. The mediator tries to say, okay, this isn't that big of a deal, or it is a big deal, or whatever. And then usually they withdraw the contempt with some kind of modification so it doesn't happen again. If the parties are not willing to withdraw the contempt, it goes in front of a judge, and then the judge will maybe find them in contempt, maybe not, but it's very rare. And usually if they find them in contempt, unless it's like abscond with the kid to like, Florida or something, then it's usually like, here's a $200 fine, don't do it again. Like, it's very, unless they abscond or like something totally insane, where I did have a case where they absconded. But other than that, it's very rare. Do you guys see it often?
I mean,
I would say it's fairly often.
Yeah.
I mean,
Really?
Yeah,
Yeah.
very often and almost.
Yeah.
I mean, particularly when it comes to non-payment of child support, of course.
Yeah.
That's where we see
that's your no-brainer
enforcements
there.
most frequently.
But do you guys have to do that?
Well, sometimes the OAG will bring the suit because in in Texas, if the non-custodial parents obligated to pay the child support, and then if the children are on government-assisted health insurance, then the state now has an interest in that case specifically because they want reimbursement for the government-assisted insurance. So if your kid's on Medicaid, your baby daddy's paying the state back for the Medicaid. That's basically what that boils down to, right? And then the order will also say they're going to pay the child support to mom. So if dad is behind in the child support, he's probably going to be inherently behind and also paying the state back, right? So then now it's like maybe instead of mom bringing the case for the, hey, I want to enforce the fact that he should be paying child support, then the state will say, well, we're going to file an enforcement because we want our money for the Medicaid, But then it's kind of like a win for mom too, because she's like, well, great, because that means that you're not just asking the court to enforce that, he pay you back for the Medicaid, but that he also pay me back, catch up on his child support payments,
So let me ask you this. So, for example, if, let's say the kid is not on state insurance. You have mom and dad has what we would call every other weekend typical schedule. I don't know if that's typical for you, but and he's supposed to pay, I don't know, $1,000 a month. I'm making this up, and he doesn't pay it. Can you guys bring an enforcement?
Absolutely.
Oh no,
That's
not
crazy.
by us.
Really?
No,
So they just rely on.
the domestic relations office enforcement officer has to bring the enforcement.
But they have like a stack of probably like this high, and they may never get to it.
Well,
I mean,
that's exactly the issue is that,
Yeah.
I always tell clients at the conclusion of representation, the OAG can and will assist you in the enforcement of child support, not possession and access. But what I often have those same clients come back to me later because, hey, I reached out to the OAG, but, they tell me I have to wait 6 months for non-payment. And while it's
crazy.
true that
Yeah.
you don't want to bring an enforcement for someone for missing just 1 month because the court typically does want to see a pattern of behavior there.
Right.
But one of the benefits of having a private attorney bring an enforcement on your behalf is that the law says, the family code says that the court shall order reimbursement of reasonable and necessary attorney's fees unless there's some good cause, right? For example, if the non-custodial parent maybe fell down on their luck or they've been hospitalized and they just haven't been able to work, well, then the court may cut them a break. But if somebody's just sitting on their mom's couch and they're getting a new job every couple of weeks so they can avoid garnishment, well, then we should hold them to task and we should order attorney's fees so that know that this is unacceptable and you shouldn't do this.
right.
Wow, that's crazy to me. Mind blowing.
I think that so you're not able to file your own enforcements then. They just have to wait. And then if the DRO does file the case, then do they hire counsel then at that point to represent them in the capacity of, that a private counsel would, or do they just rely on the DRO?
So for example, if dad's paying, DRO will file the contempt against dad. The DRO will bring dad into court, and then mom doesn't even have to show up. And then the judge will say, okay, you're $8,000 in arrears. You're going to go to, XX jail, and you can purge with the amount of a payment of $1,000 directly to mother.
Basically like a cash bond.
Yeah, like that's how you can get out. So, but mom doesn't have to appear. So people call me all the time and like, hey, he's missed 3 months and like, I can't pay my rent. Like, I'm really struggling. What do I do? And I'm like, call your enforcement officer. There's nothing we can do to bring that. Now we can petition to modify and decrease, increase, get credit for maybe another child in a different county or something, but I can't do anything on enforcement.
What's your typical turnaround time? And I feel like that's a very frustrating question that we get asked sometimes because it's like, when is my case going to be over? How long is this going to take, right? But
An attorney's favorite answer.
like,
It depends.
it depends. Yeah, so it depends on what? Like, what determines what the typical turnaround time is over there?
Do you mean
For a case, sorry. Yeah, so like for a modification.
of custody?
Yeah.
So usually we get a mediation date within 4 to 6 weeks. And then
But what if you have to do discovery beforehand?
we have to get an order for specific discovery.
That is wild.
So
That is
I'm not doing
Yeah.
talking divorce, I'm talking just custody.
Just custody, yeah.
If I want discovery in a custody case, I have to have what we call good cause and walk into court and present why I need discovery in a custody case.
So it sounds like you have to ask for a lot of permission from the courts to just lawyer and litigate, right? Under what Texas Rules of Civil Procedures just allow for. Are the courts accessible there? Like if you had to walk in and
Right.
ask for the opportunity to, I guess, serve discovery, could you just go in same day or do you have to wait?
So it depends what county I'm in, but it's between 5 and 3 day rule. So I would what we call list it for motions present it to the other side in advance. Hey, I'm presenting this motion on Friday, May 20th, Friday, May 20th, and, you can be here. Most parties, most lawyers, I could say, hey, can we stipulate that you're going to get me X, Y, and Z? And then usually most people are okay with it, but there's usually nothing that I need discovery for. So like my client usually has what I need. For example,
Right.
We have like the 16 custody best interest factors, and it's like report card, vaccine form, map of your residence or how far it is to the school, the child's bedroom, any special needs, an IUP, things like that.
Yeah.
So they usually have all of that. So it's rare that we need discovery.
But so then if the case doesn't settle at mediation, I guess my next concern would be, well, I need to know what they're going to present as exhibits in trial. Discovery would have already given me like a preview of that, an indication. And if it wasn't produced in discovery, well, then they can't use that in trial, right? So do you find that if you don't settle in a mediation, that most litigants are going to do discovery after that? Or is it just like you don't have to present, or that's not the rule, like in trial, they can present anything even if it wasn't produced in discovery?
So we give a pretrial statement.
Okay.
So I would send you like, hey, here's my witnesses, here's copies of my exhibits, this is my proposed resolution. Scan you a big packet, email it to you. And then if it's not in there, then it's precluded from being presented at trial. My problem is sometimes we have pro se litigants. They don't know how to read an order. They don't know how to file a pretrial statement. And then I'm jumping up and down at the top of my lungs when they want to put their mother on the stand about, custodial stuff. And I'm
Yeah.
like, wait a minute, you didn't put me on notice of this.
Yeah.
Right. So, and, that's like, I feel bad because like the general public doesn't know.
They don't know.
And
Yeah.
like, I have to do my job, of course, and advocate for my client. But like, they don't know. And sometimes we're fighting over things that are like just beyond like pick up after school or at 6 p.m. Like, and I try to not go to trial over something like that.
Right.
But if I have
Yeah.
a pro se person on the other side, they don't understand what you're getting into, kind of. I mean, a trial is a big undertaking.
Yeah.
And they don't maybe understand that, especially because a lot of people think, well, I went to mediation, which is like this. It's like a conference.
Yeah.
So maybe I'm coming back for another conference. And it's like, no, dude, you're in front of a judge. You better like put
Yeah.
your witnesses on the stand. And
Yeah.
they're not sure.
And that can be very frustrating, like dealing with the opposing side that does not have an attorney. They're a pro se litigant. They represent themselves, right? Because sometimes we'll get clients that'll say like, "Oh no, it's good. Like he doesn't have an attorney. This is gonna be fine.
Yep.
Like it's gonna be fast." And I'm like, no, that's actually, if he's going to challenge your suit, that's actually gonna complicate things more because he does not have an attorney that is representing, or that's advising him. So in other words, like he doesn't have somebody in his ear saying you're being unreasonable, so let's shift the strategy, and then it can just prolong the case.
Exactly. Sometimes working with a pro se is more difficult,
It
just like
is.
you said, because they don't have an attorney to say, hey,
Yeah.
this is normal, this is standard. They're not trying to get you. This is just what we do.
Exactly.
Yeah,
exactly.
it's honestly, for me, it's worse because now I have to email you and I have to call you and they're like, well, what, you served me a paper that says blah, blah, blah. And I'm like, yeah, I can't tell you what that means. I can't give you any advice. You got to go talk to a lawyer.
Yeah.
Sorry.
So it's
And
like you're negotiating with somebody that has a lot of questions, but it's like,
Yes.
I can't answer those questions. You're just supposed to know the answers.
Yes.
But I need an answer to my negotiation. You know what I mean? So yeah, it can be very challenging
I
dealing
also
with.
find a lot of pro ses just won't talk to you.
Yeah, they'll just
Yeah,
they
they
Just
won't.
they don't
Yeah.
think they have to.
Yeah.
And it's like, if you don't have a representative or an attorney, who else am I supposed to talk to?
Yeah.
Or you get the age old, I'm hiring an attorney, you'll hear from them next week, and then it's crickets.
Yeah.
And
Next week
you
becomes
never,
next year.
And that
Yeah,
means that
you
we
just
have
never
to
hear anything.
We have to file motions to compel the
yep.
mediation.
And it makes the case more expensive.
Exactly.
And then the client's like, oh, I'm paying you all this money.
And he doesn't even have an
you know,
attorney.
What
I'm
if we
like-
accomplished? And
It's like we're trying to just push it forward, but we can't because he doesn't have an attorney. So we have to file the proper motions in place because it's not that like, oh, if he doesn't have an attorney and he ghosts us, then the case is just going to sit at a standstill, because there are those tools in place where we can get the case moving forward, but then we have to ask the judge for more permission to do certain things, and we have to ask them to order him to participate to the extent of mediation, et cetera, right? And yeah, it can be very frustrating if we have to do those extra things that had they had an attorney, the attorney would have just told them like, we're just going to do it because we have to do it.
Yeah, particularly for us, for divorce cases, speaking about discovery, like motion to compel, and we do a motion to compel, which means you got to give me your documents. You know, I gave you your 30 days, you didn't give them to me. So we do a motion to compel, and then we get an order that says typically 10 days, right? Then they don't give them in 10 days. Then I do a motion to enforce and a motion for sanctions. Okay, we're enforcing the order. You have 5 days, and you got to pay, you know, $200 fine. And then it's like, what if they still don't do it? What just happened, believe it or not? And then it's like, okay, now I'm asking for a bench warrant. Because what do you want me to do? I can't move this divorce case any forward if I don't know the assets. And my client, she or he is paying for me to go to 1, 2, 3, 4 now court hearings and prepare 4 documents and list 4 documents. And it's like, I'm charging them because obviously I have to make money and do my job, but I feel bad.
I think it's just gotten, like, the family court system has just gotten so out of hand that it's become, like, we understand why there's layers to it and why there's complexities, but it's not for the lay person. It is not for the lay individual, and trying to go through the family court system as a lay person can seem impossible, and it's almost like you're setting yourself up for failure. It shouldn't have to be that way because not everybody has the money to hire an attorney. They need to make, you know, the family court system more accessible to navigate. And that's why, you know, when lawyers like Allie and I are going on social media trying to educate the public about, like, hey, you know, this is what joint managing means. This is what sole managing means. Like, we are just making it a little bit more accessible for them to navigate through and for them to understand. And so I want, like, anybody that's watching this to be kind to, you know, your social media lawyers, because it's a service. It is a service to have to go on there. It's not just marketing. It's a service of just providing free educational content. And what it's doing is it's making, you know, legal education more accessible to people.
Yeah, and I think you know, it's explaining things in a way that I would explain to you at a consultation, right? So we charge a consultation fee. I'm sure you charge a consultation fee, and now you're getting the explanation of what we call sole and legal custody for literally in a 2-minute video for $0, right? And I don't do that to market myself or make money. What I'm doing it for is to explain it to the general public, because let's be honest, every single person we know or someone, if it's not us, it's somebody very close to us, has, you know, either single mom, single dad, your sister, your brother, your uncle. Everybody knows somebody going through a family law issue, whether it's divorce, custody, PFA, child support, CPS. I mean, it's rapid fire. It's more common than it's not anymore.
Yeah. And it's there's such a big benefit to it, because it's like by the time the client reaches us, they're like, oh, okay, I have these issues, but I've already watched your videos on this, and that, right? And if I go on social media and I say, hey, probably not a good idea to block your baby daddy, so don't do that, right? Then we get, you know, pushback from certain practitioners that they're like, no, you can't do that. Like, you're giving legal advice, you know, and you're not allowed to say those things. But I'm like, what I'm doing is I'm actually creating less litigants, less cases in an already overwhelmed system, because now they know to be smart with their co-parent and not block them, you know? And so it's a service.
Yeah, it's a service, and I think that's like a big issue, particularly where I practice, is if you don't agree at mediation, well, we'll just see you at trial. And it's like, now I get the trial list and I have 9 cases in a week, right? Because that's the way they batch it. And I'm like, why are we doing this? Like, we're fighting over things like, can my kid play football? Is the exchange, you know, at 3 or 6? Like, a lot of, like, minute details, which matter. They really do matter. But we can work this out. We can, like, figure this out, particularly if there's another attorney on the other side. But they're just so quick to throw their hands up.
What really helps us in those situations is that we have presumptions in the family code. So does your family code, like our standard possession order, it's like, if you don't agree on a schedule, that's your default schedule. Unless you're going to be able to overcome the presumption, right? Like, bring good evidence to say that that schedule is not going to be workable, it's not in the best interest of your child. Now the opposing counsel knows, hey, you know, like, if our client didn't want the standard possession order, for dad to have the standard possession order, we would assess whether or not we would be able to bring the evidence forward in court to basically ask for something different, right? But that also helps us in mediations to reach more settlements, because now what we're doing is we're advising our client, like, hey, we should settle in this case because we do not have the evidence to overcome that presumption, right? so having that already built out schedule, having those presumptions in the family code help towards reaching more settlement negotiations. Does Pennsylvania already have like a default schedule put into place?
No, we have like common ones that like us standard practitioners use every other weekend, what we call a 225 or a 443. But those are just common, like made up by us practitioners. There's not like one set out. So it's often based off the child's schooling, school age, extracurricular activities, parents' work schedule. That's given that both parents are fit, willing, able. If they're not fit, willing, able, then we're having a totally different discussion. We often see like week on, week off. I don't know if that's common here, but we very rare for us, very rare.
Yeah.
But it's either in every other weekend or some form of the 50-50, which is either a 225 or a 443 for us. So
That mirrors, I mean, every other weekend effectively is what
Right.
first, third, and fifth
First, third, and
weekends
fifth
are.
weekends.
they're okay.
You know, most months don't have a fifth weekend, but
Yeah.
Do you guys see, this is probably a hard question actually, but do you guys see more of an every other weekend or more of a 50-50?
Well,
If you take it to trial, is
if we take it to trial, it's going to be more likely than not the first, third, and fifth weekend. Yeah, the every other weekend,
okay,
because that's
all
the
right.
presumption.
So,
The
okay.
family
many
codes.
courts are reluctant to deviate from that.
Yeah.
And I've
Really?
I've been in courts
Yeah.
where the judge has said if these parents want 50-50, they better reach that agreement amongst themselves because they won't be getting it from me. And if I hear this case at trial, one parent will be getting a standard possession order.
our presumption is 50-50.
Yeah. How many miles do the parties have to live like within each other to get the 50-50?
There's not a mileage like
That's like opening up the door for
number,
so much.
but so it's can they get them if they're school age? Can they get them to school within a reasonable amount of time, and can they get them to their extracurricular activities? So, like if for example somebody lives in Easton and Peaburg, which means nothing to you, but that's literally a 5-minute drive across the bridge, right? But 2 different states. I could easily get my kid if I live in New Jersey to
Yeah.
Easton High School. It's literally a 5-minute drive.
Yeah.
But if I'm in Allentown and then Phillipsburg, which is more like a 35-minute drive, and I have to be at work at 9 a.m., but my kid needs dropped off at 8:30, the timing doesn't match. So then they're going to say, you can't do 50-50.
But that also leaves for a lot of like, oh, okay, so you're saying that they would time it then.
It's
more
all about
likely than
timing.
not.
Like, can we fit this in with work and school?
In Texas, it's all about physical distance under the standard possession
Yeah.
order. So it used to be when I first started practicing that it was parents who live within 100 miles, parents who live over 100 miles apart. But
100 miles? That's
Yeah.
long.
But that was also
But that's
before.
why it's different, right? And that's why we anticipate people
Yeah.
living within 100 miles are going to have an easier time doing certain things, picking up when school lets out, or returning the child when school resumes versus a parent who lives over 100 miles away, because it may be that you're having to get your child up at 4 a.m.
Yeah.
to take them to school, and that probably isn't in your child's best interest developmentally because they need that sleep. And so
Yeah. And that was also before like the expanded standard possession order.
exactly. And
which
so
is
in 2021, that's when we added that new increment for parents who live under 50 miles apart.
then they're like, if y'all live within 50 miles apart, then you're close enough to, you don't have to pick up the kid on Friday at 6 p.m. You can pick up the kid at school.
So
And
if me and you are married and we have a kid, and I live 50 miles from you, the presumption is 50-50?
No, it's a standard possession order. Well, it's an expanded standard possession order, which is basically like 45, like 60, 35, like, wait, what is it? They did the math one time where they like broke it down, but basically it's almost 50-50, but it's not.
Exactly. And that's
Yeah.
why the legislature in 2021 implemented those alternative beginning and ending times, because they were trying to create more equity between the custodial and non-custodial parents.
So if I live 51 miles from you, it's going to be first, third, fifth.
So
roughly.
not necessarily. So the family code says that parents who live within 100 miles apart, it's the non-custodial parents' election to say whether
can
or not
choose.
they want those extended pickup and return times.
Wow.
When you live within 50 miles, the presumption is that that's in your child's best interest. And so it gives you a little bit more wiggle room between 50 and 100, because obviously that could present logistical issues, especially in Houston, because
Yeah.
Houston is such an expansive geographic area that if you live 50 miles apart, that could mean 2 hours transport both ways with our traffic,
And it
depending on the different areas.
And it sounds like, I guess that's what Pennsylvania's like mindset rationale is with their is, that we're not looking at the physical distances. Like, is this like physically possible to achieve?
Yes. Is it?
Yeah.
It's basically, is it physically possible to achieve? So what we often see is if we have two fit, willing, able parents, but let's say one has to be at work at 7 and school starts at 8, right? So I can't ever take my kid to school. They all do like what we call extended weekends. So it's like an extended, what you would call first, third, fifth. So like maybe it's Friday after school to Monday night, and my mom is going to pick up the child or something like that, right? So they'll give extended weekends, or in the summer they'll alternate it to. So we often have, I don't know if this is common for you, but a school schedule and a summer schedule.
We do, yeah.
Okay, so like in the summer, it's more likely we have parents with 50-50, or we expand the 50-50 to week on, week off, so the parents can take like vacation. But in the school year, it's all about getting to the kid to school and extracurriculars on time with a sound mind. So
That's crazy though, because then what that does is like, well, in one way I like it because that means that it's putting the responsibility on the parent, to say, is this physically possible for you to achieve? Are you, parent, able to pick up and drop off, right?
Yep.
But over here in Texas, what we have is we just have this like, okay, if you're not physically able to, you can just designate a competent adult. And then now we're having a lot of people saying, well, he's always sending his girlfriend to pick up the kid, or he's always sending grandma, and and that becomes a whole nother issue.
yep.
Yeah. Basically, bottom line is that, it's exactly the reason. If you reach out to Allie on, social media and you ask her like, hey, can you just consult with me? The answer is no. Like if she's not licensed in your state, right? And the same thing for me, because after watching this episode, I hope the one thing that you can take away from it is that family law differs from state to state. Allie, thank you so much for being here with us today. Jody, thank you for joining us, and catch us on the next episode of See Your Baby Daddy.